The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Hi, I'm Kevin O'Flaherty. I hope you enjoyed this Learn About Law video and podcast presented by O'Flaherty Law. If you need some help, please feel free to give us a call at 563-503-6910. That's 563-503-6910. We offer free consultations in many areas of law, and we have several geographic locations for your convenience. Thanks again for watching and listening.
This is Andrew with Learn About Law, and in today's video, we'll be covering Iowa independent contractor agreements. We'll explain the different clauses and stipulations typically found on an independent contractor agreement in Iowa. So as a business owner or worker, the two most common legal categories of people who will do work for a company are going to be an employee and an independent contractor. Having the proper legal contract created with professional legal input will ease your mind and the mind of your employees or independent contractors. Every business has its idiosyncrasies, and the independent contractor agreement for your tech business may be different from your friend's construction business. However, most independent contractor agreements share common clauses and stipulations. The purpose of a properly drafted independent contractor agreement is to, one, establish that the relationship between your business and the independent contractor that you are contracting with will be seen as an independent contractor and not an employee when viewed by the courts, and two, to protect your business should any legal disputes arise between your company and the independent contractor. So I'm going to talk about some of the more common items in an Iowa independent contractor agreement, kind of list them off. And while this list is not exhaustive, it discusses the important items that should be found on almost all agreements. So first, we've got parties involved. This is pretty straightforward, but all parties associated with the work, including the person contracted for the work, the company contracting the work, the time frame of the work as far as it can be established, and any pertinent geographic information. Second, we've got scope of work. This category is crucial and is often the point of dispute when it comes to a legal case involving an independently contracted employee or an independent contractor. You could argue that the independent contractor would want a more specific scope of work detailing what the work involves. This skills required, what is considered completion of project, etc., while the employer might want to have a broader scope of work as to provide a type of blanket coverage. Typically, when under legal scrutiny, specific detail is better. Broader, more ambiguous scope of work leaves room for interpretation by the court, which creates uncertainty for both sides. Third, we have payment clause. This clause should detail the pay rate or sum for the work being done and completed and should reference the completion of work as detailed in the scope of work clause. Then we have due date. There should be an agreement on a specific due date, no specific due date listed, or more detailed stipulations on certain deadlines associated with the project. Then we have expenses and taxes. In Iowa, there will normally be two options under this clause. One, the independent contractor is responsible for all expenses and taxes, and two, the independent contractor should be reimbursed for designated expenses directly associated with the services under the agreement. In the second scenario, stipulations should be included indicating in what time frame the independent contractor is to be paid after the company has received the itemized expense statement. Having the independent contractor be responsible for all expenses and taxes is typically the safest choice with regard to having the agreement appear as a true independent contractor agreement in court. So number 5, liability insurance. It is normal for an independent contractor to have their own liability insurance coming into a job or before starting a job. This clause can also stipulate a minimum dollar amount of liability insurance. 6 is going to be the termination option or option to terminate. This clause should contain the stipulations for termination of the contract. This does not necessarily mean termination as in being fired, but rather the end of the contract, right? It may contain multiple stipulations such as a specific date, the project ends, the whether completed or not, termination upon completion, or some other written agreement on contract termination. And a note of caution with IC termination clauses in Iowa, both sides should avoid one or the other, including a termination for any reason at any time clause in the agreement. Under the Court of Law in Iowa, this would indicate an employee at will agreement and could lead to some legal headaches. Instead, it is best to include language stating a time frame for notice of termination due to material breach of the contract or actions from either party exposing the other party to personal injury or property damage. Next up, we have independent contractor status under the IRS. This clause can be confusing as written on most contracts, but it is essentially language reinstating that the independent contractor is actually an independent contractor and includes other stipulations such as the contractor nor the contractor's employees being required to wear uniforms provided by the client, and other stipulations explaining the relationship between an independent contractor and a company as laid out by the IRS. Next up is going to be licenses, permits, etc. The IC is agreeing that they and their employees will have acquired all proper licenses, permits, etc. for the work to be done. Then there's taxes, benefits, and compensations. Under an independent contractor agreement, these clauses would stipulate that any taxes, benefits, compensations, etc. would be the responsibility of the independent contractor. These clauses typically apply to employees of the independent contractor. Then we've got indemnification. The independent contractor shall indemnify and hold the client harmless from all liability and loss associated with the contracted project. Confidentiality. This clause discusses the likelihood of the contractor being given confidential business information and the agreement to not share this information with a third party unless expressly written and agreed upon by the client. Proprietary information. This section illustrates what is considered proprietary information under the contract and discusses clients' rights with regard to that proprietary information. Typically, the company is protecting any and all proprietary information, so the independent contractor can't just take it to another company and profit. Non-compete. At times, it may be important for the client to create a clause stating that the contractor cannot engage with another business similar or different from yours and within a certain geographic area. Non-competes can sometimes be difficult to enforce, but should always be included if necessary. Enforcement. Having a clause that legally holds either party liable for costs associated with the breach of contract or costs associated with legally enforcing the contract may seem harsh, but it will give peace of mind to both parties and serve to make enforcement of the contract affordable if a dispute arises between the client and the contractor. Without an enforcement clause, the cost of hiring legal help to enforce the contract might outweigh the cost of the job itself. So again, this list is by no means exhaustive, and every client contracting a relationship is going to be different. Due diligence on both sides and working with a good attorney can help you avoid common headaches associated with independent contractor cases. Review your situation and draft an appropriate contract for the work to be done. Thanks for tuning in.
Hi, Kevin O'Flaherty again. Hope you enjoyed that presentation of Learn About Law presented by O'Flaherty Law. If you need some help, please give us a call, 563-503-6910, 563-503-6910. Again, we offer free consultations in many areas of law, and we have several geographic locations for your convenience. If you found this helpful, we'd love it if you'd subscribe to us on YouTube, SoundCloud, Apple Podcasts, or wherever you listen to your podcasts or watch your videos. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.